Friends, good morning to all of you. I hope tomorrow we will all support Janata curfew on the call given by our Prime Minister Sri Narendra Modi ji. Right. Today, in the topic of the Contempt of the Courts Act, we are going to discuss a case law. I think you are certain to know the legal provisions of the Contempt of the Courts Act 1971. It is a very simple act having only 30 sections of law, and I hope you understand that contempt is nothing but obstructing the administration of justice by your act. It may be civil contempt or it may be criminal contempt. Section 2 says civil contempt means disobedience to any decree, any judgment, any order, any writ, any direction or anything given by the civil court. Of course, criminal complaint means any act or any publication which prejudices, which jeopardizes, which interferes in the administration of the justice system. Section 12 says about the punishment for the contempt. So you all know that the punishment should not exceed 6 months and the fine 2,000 rupees. And also, the contempt of court can be initiated against normally the advocates, against the civilians, against the judges. So under anybody can be taken to the task of contempt. So section 12 says even though 6 months punishment is given, if you apologize, it will be treated as punishment also. So briefly, this is punishment. Here, yesterday, the Supreme Court Justices Srimati Bhanumati and A.S. Bopanna, while disposing the civil appeal number 22210 by 2020 in the famous case law Shyam Sahani versus Arjun Prakash and others. While disposing, the case arose out of OS number 1134 by 2018. If we go into the facts of the case, basically this is a civil case. So a civil suit was filed in the Delhi High Court seeking declaration, number 1. Number 2, permanent injunction, and also possession of the suit scheduled property which is pending between the two relatives, that is Shyam Sahani and Arjun Pankaj, right? So Arjun Pankaj, the High Court has given clear-cut direction and it has given a permanent injunction against against Arjun Pankaj, stating that the single judge, stating that it has given interim injunction restraining the defendant Arjun Prakash from selling the property and from alienating the property to others or creating a third party registration. These three things should not be done. He is restrained because the property was of heavy value. It's a complex. So many people are there for rent and the dispute regarding the partition. Both of them are claiming, both parties are claiming title over the property. So all of them are big shots. So at this juncture, since the injunction order is violated, then the Delhi High Court took it as a contempt. Definitely, already I told you, section 2 says whenever the direction given by the court is violated, definitely it amounts to contempt of the court. Even the government officers, suppose if the government employee goes to the tribunal or high court and gets an order of reinstatement, if the concerned officer does not reinstate him, then the government employee will file a case of contempt against the officer and it will be taken up also. Likewise, here, since he is contempt action has been taken against the defendant, since he refused, right? So here it came to the notice of the court when the petitioner, that is Sham Sahani, he filed an application before the court alleging disobedience of the injunction orders given by the High Court. So he filed a petition under Order 39, Rule Rule 24, and also Section 12 and 10 of the Contempt of the Courts Act. So the court called the defendant or the respondent before the bench and since they took it as a contempt, then the court asked him to deposit his passport because he is a big shot and he is likely to visit so many places under the name of visit to other countries. If it doesn't turn up, the entire contempt proceedings will be delayed. Therefore, the court single judge bench gave a direction that his passport should be deposited. So now this is the problem, crux of the problem. Now he approached the division bench of the Delhi High Court. The division bench actually is of opinion that the single bench has exceeded the jurisdiction and asked the contemptor to deposit the passport, which is not necessary. And agreed by this order, then the matter came to the Supreme Court. Now Justice Bhanumati and Justice Bopanna upheld the decision given by the single judge. They held that the division by the order of depositing or surrender of the passport is with the intention that he should not leave India. That's all. They are not going to confiscate the passport. So once the passport is deposited with the court, he cannot go out of the country till the issue is settled. So in order to see that justice is done quickly and in order to see that the contempt proceedings are disposed quickly till he purges out of the contempt, then the court asked him to deposit the passport. Yes, 100%. So it cannot be said to be a judge exceeding the jurisdiction. So the single judge is correct. So this is what the Supreme Court held. So please remember, at times there are occasions where the judges may ask you to deposit the so-called passport. Normally, in case of 439 CRPC, anticipatory bail and like things in criminal case also, they will give a direction that the passport has to be surrendered before the concerned police station and he should not leave India without permission from the court. Otherwise, what happens, you know very well the case of Vijay Mallya. So it is very or Nirav Modi, which are very difficult to have the efforts, even though the efforts sincerely made by the government to bring them back, they are futile. Really, till now, after 5 or 6 years also, we couldn't bring them back. Suppose if the passport is impounded, then he cannot go out. That's why definitely such action is not violative of the that is fundamental rights. Therefore, the Honorable Single Judge Bench held to be correctly asking the defendant to surrender his passport. So this is a case law. Please remember, at times the court may be able to give such directions. After all, I have been telling you, contempt of court is a very simple act and the punishment is after all 6 months. So the fine is also only 2,000 rupees. But still, people for big shots, this is an obstacle. Otherwise, if he is intelligent enough, he can go to the other country and the matter will be delayed. So to prevent him from going like that, the court has thought over the matter. Because when once the injunction order is given, it is his duty to bind to the injunction order. He should not violate the injunction order. The injunction order is given not to alienate, not to sell, not to register to a third party. So these things should have been done. But already this complex is attached to another third party and he started collecting the so-called danda, which is brought to the notice of the judge, and therefore only the passport has to be almost not impounded, has to be deposited with the court. The intention is good. The intention is to see that the contempt proceedings are initiated as quickly as possible, because the problem is when once the contempt is taken, it has to be tried by the High Court, then appeal to the Supreme Court only. No other junior court can do it. Therefore, in order to see that the matter is disposed of quickly, they have ordered for the deposit of the passport, and it is held to be correct as per the decision by the Supreme Court. Thank you.